Yes.
Just in approaching the neighbors, if you could also give notice to those people who wrote letters, and so they could be involved in the discussion as well.
Definitely
As
will.
well as Mrs. Marlowe.
Mrs. Marlowe?
Mrs. Marlowe in Atlanta needs to be in on it.
Mrs. Marlowe in Atlanta.
She wrote the letter.
the letter,
Oh,
the
okay.
first one we got,
I don't know what's good for your schedule, so.
not Thursday.
That's the week of the 17th, that's about a month.
I've got a crazy week that week. I'm busy though, I'm busy all 3 nights, so unless it were a Monday.
Monday, the 17th, can we do it then? I mean, it's open for us to do it.
Not in the blue to be here again.
We'll be here in this room, that's fine. All right, so Monday, November 17th at 7:30 here in the Corona Conference Room, is that?
It's not Veterans Day, is it?
Uh,
Okay.
Okay, everyone have that? Monday, November 17th, 7:30 in this room, we'll meet again.
Thank you very much.
You're welcome. Thank you to you all. Yep. Sorry? Okay.
Nice meeting you too. We'll see you again. We'll see you on the 17th. Proactive, moving forward. That was good. That's the only way, that's the only way you solve it.
Package?
Yeah, did I stick it in?
We go first.
Yes.
Should I wait till you're ready, or should I pass this stuff out, or wait for,
Let's just wait for Mary to come back, okay, if you don't mind. Okay, you represent, okay. Yeah, no, I haven't yet, but it's next. You're welcome to sit down.
you're representing the Oaklands package for you?
Mary, is Mr. Prondak going to be here tonight? Is he?
In his office.
Okay. Okay. Okay.
Based on this TV camera.
You ready to begin?
Oh my God, it's awful. Okay. All right, I can see.
Mary?
So when we start, do we just go over the inventory?
Yeah, just give me a second. Why don't we open the public hearing? I'm going to call to order the third public hearing of the evening, which was scheduled for 8 p.m., and I apologize that we were delayed in getting started. The last hearing took a little bit longer than I think we had scheduled it for. This third hearing this evening is on the application of Philip Johanning, the appellant of 23 Parkwood Drive, and that application was dated August 18th, 2014, pursuant to Section 9D of the Milton zoning bylaw and General Laws, Chapter 48, Sections 8 and 15, appealing a determination by the Milton Building Commission dated August 10, 2014, that their nursery use is not in violation of recent Board of Appeals decisions or a court, it says inspection, or probably a court decision or injunction. Mr. Johanning resides at 23 Parkwood Drive, which abuts the property owned and operated by Thea Nursery. Mr. Johanning contends that Thea Nursery continues to operate a commercial landscaping business in contravention of the decision of the Zoning Board of Appeals and a June 10th injunction issued by the Norfolk Superior Court. The Milton Building Inspector advises that he has found, based on a number of unannounced visits to the property, that Thea Nursery was in compliance with both the decision of the Milton Zoning Board of Appeals and the terms and provisions of the Norfolk Superior Court injunction. And Mr. Johanning has appealed from that decision dated August 4, 2014 by the Building Commissioner. At this point, prior to receiving some additional information I know you want to give us tonight, the application consists of the record consists of the notice that I've just read, an application dated August 18, 2014 by Mr. Johanning, a letter from Mr. Prondak to Mr. Johanning and John Rowe dated August 4th, 2014, advising that he believes that the operation was in compliance with these particular orders and injunctions that we've just referenced, and that's the record that we have at this point, I believe. Mary, I think there's some additional information that Mr. Johanning wants to present to us this evening. And if you would, perhaps you could describe what it is, rather than
Good
my...
evening, my name is John Rowe from 23 Parkwood Drive. What we've put in the package for the board members is the building inspector's determination that Thea Nursery is in compliance of recent Suffolk or Norfolk County cease and desist order, as well as orders by this board, one in February of 2014 and the other in September of 2013. So as Mr. Hurley and Mrs. King are very familiar with the case, I've put these things in here for Mr. Gray's benefit, as he may not be as familiar. This seems to be a merry-go-round that we're on. Every few months we're in front of this board. So the first exhibit is Mr. Prondak's letter. The second exhibit is the cease and desist order issued by Judge Wilson of Norfolk Superior Court dated June 10th, 2014, in which he orders Thea Nursery to cease and desist all landscaping activities, as were ordered by this board in their September 2013 ruling, which is the next attachment. And then the fourth attachment is the Board of Appeals ruling and cease and desist order for the firewood distribution business that has been operating on the property. And then the fifth exhibit is the Commonwealth of Massachusetts Land Court judgment in the Coulter case by Judge Sands, which is the premise of this board's decisions in 2013 and 2014, as well as Norfolk Superior Court's decision. And what this is all based on is the town zoning bylaws do not allow for this commercial activity to take place with a variance from this board. It requires a use variance, in which Thayer does not have. So, and then the final exhibits are pictures of Thayer Nursery taken from Forest Street, taken from Pam Lepori's property, and taken from Forest Street, as well as Briarbrook Road, various landscaping jobs. So I'd like to note that Mr. Prondak determination letter dated August 4th, in which he indicated that Thayer Nursery was in compliance with the cease and desist order issued by Norfolk Superior Court, as well as the cease and desist orders issued by this board in September. I'd like to note that Mr. Prondak only visited Thayer Nursery on one occasion, and that was on June 24th of 2014. He did visit a site in Canton where it appears that Thayer Nursery had stored some landscaping equipment. However, we do not believe that they have moved their landscaping business, and they continue to operate the landscaping business as well as operate the firewood distribution business on the property. I'd like to go through the pictures. Okay, so the first picture is of the 5 dump trucks that are owned by Thayer Nursery, parked at 270 Hillside Street, which they're parked there permanently. They're not parked anyplace else, and these are the dump trucks that are used in the landscaping business. There's also a pile of mulch that is used in the landscaping business. So that's pictures 1, 2, 3. Picture number 4, you can see a flatbed trailer that's used to put equipment on, such as front-end loaders to take to landscaping jobs. And then the next picture, you can see 2 dump trucks, the mulch pile, as well as an excavator that is also used on the landscaping jobs. We do not believe that a nursery requires this type of equipment. And apparently, this board's orders, I think came to that same conclusion. However, the building commissioner, well, I guess he does not agree with the board. So anyway, if you put the pictures together, you can count all 5 dump trucks. The next picture is a pile of loam used in the landscaping business, this one with a tree in front of it. The next picture is a pile of construction materials. There's crushed stone you see in the picture that's used in the landscaping business. There's paver stones as well as cinder blocks. And this is also on the property at 270 Hillside Street. These pictures were all taken on August 17, 2014. The next picture is of a Thayer Nursery dump truck and an employee. I don't know if he's unloading or taking the trailer off of the truck. And this is taken in front of 80 Briarbrook Street. This picture was taken on August 11th at approximately 7:30 in the morning at my home I heard the dump truck leave Thayer Nursery at 270 Hillside Street. And I went out, and it went from 270 Hillside Street down, well, actually, it's the Forest Street entrance to 270 Hillside Street. Proceeded down Forest, down Parkwood to Briarbrook, where they did a landscaping job at, I believe they did a job at 80 Briarbrook that appeared to be edging of beds and mulch. And you can see the tractors in front of 80 Briarbrook Street. And then they did a landscaping job. It appears that they planted shrubberies at 90 Briarbrook Street. And these are the pictures of, there's a big pile of mulch where they put mulch in at Briarbrook Street. And so these are landscaping activities, and Thayer continues to use 270 Hillside Street as a staging area for their landscaping business. So again, these pictures were taken on August 11th. The last series of pictures were taken on October 4th. This was a Saturday, and it's kind of blurry. I happened to be going down Forest Street, and in front of me, a dump truck pulled out of 270 Hillside Street, the Forest Street entrance. You can see it coming out of the entrance. And the dump truck is filled with kiln-dried firewood. I followed the truck down the street. When they got to Hillside Street, it took a left. And if you see the last two pictures, October 4th was a Saturday. It was a rainy day. They had a tarp over the dump truck to cover the wood. But I think you can make out, just on top of the sign, the wood in the dump truck. On that day, I witnessed from my backyard, I can go to my back fence and see them drive trucks into the wood warehouse, and I can hear them load these trucks with the front-end loaders. It makes quite a racket when you have a front-end loader full of firewood and you dump it into a dump truck. And so I can hear this happening, and then I see the dump truck leave the warehouse and leave the property. This leads me to believe that they continue to operate their firewood distribution business from the property, which this board ordered a cease and desist of that activity in February of 2013. You know, we're not here to, I'm not here to discuss the merits of your decisions. I think those decisions are final. It's gone to Norfolk Superior Court, and the judge agreed with this board on a few occasions, one being when the Oldfields filed for a preliminary injunction on the first order, cease and desist order by this board in September of 2013, and Norfolk Superior Court Judge, I'm not sure.
Judge Wilson.
Judge Wilson denied that request, saying, you know, that they would, the basis was they were unlikely to win in an appeal of your decision at that point in time. The firewood decision this board made in February was also appealed, and that appeal was thrown out of Norfolk Superior Court. In June of 2014, the town of Milton took their nursery in front of Norfolk Superior Court requesting a cease and desist order, which Judge, what's his name? He was Wilson, right?
Broussard.
Judge Wilson issued the cease and desist. So just based on our observations and our pictures, We do not believe that Thayer is complying. We don't agree with the building commissioner's assessment, and we don't believe that Thayer is complying with your orders nor the order of Norfolk Superior Court.
I'd like to make some additional comments. This has turned into a tremendous circus.
Just for the record, you're Mr. Johanning, is that
Joe
correct?
Henning, yes.
Okay.
I'm Phil Joe Henning. I live at 23 Parkwood Drive. All these hearings have turned into a tremendous circus with supporters of Thayer Nursery coming and speaking about all types of things. But what I want to make clear is our action has to do with the enforcement of the 1938 zoning bylaws. These bylaws have been in effect for 76 years. This is about fair enforcement of the zoning bylaws. John and I had nothing to do with the enacting of the bylaws. We didn't write them, but we're asking for fair enforcement. Certain bylaws having to do with nursery and landscaping businesses have been further explained by the decision of Judge Sands in June Leiden versus Town of Milton Board of Appeals and Thomas Coulter. I believe that what Judge Sands has done is gone into many of the issues that we've talked about with Mr. DeLuna, having to do with the evolution of the business, et cetera, et cetera, et cetera. One final point I'd like to make is the law does not recognize the number of years that someone has lived in Milton as a reason for preference. I hear a lot of people saying, oh, they've been here forever. Yeah, that's true, and I agree with that. But that is not a reason for preference. What I'd like to do is walk through quickly some of the points that Judge Sands made in land court in the Coulter case, just so that we can make perfectly clear, some of the provisions of the bylaws. The first thing I'd like to talk about is on page 15 of Judge Sands' decision, just a little below the middle of the page in the new paragraph. Bylaws do not define the term nursery, but a dictionary definition of a nursery is an area where plants are grown for transplanting for use as stocks, for budding and grafting, or for sale. Now, what he's saying is they're grown. What Thayer Nursery is primarily is a staging area. Plants come in on 18-wheel trucks, and they go out on dump trucks. Very few plants are grown. The facility is frequently called a farm, but it's not a farm. It's basically 4 acres with 2 residences on the acres, on the 2 acres, on the 4 acres. So basically, there's a large parking lot and a staging area for the business. Another point that Judge Sands made on page 12 is under General Law 40A, Section 9, bylaws or ordinances shall provide for specific types of uses which shall only be permitted in specific districts upon the issuance of a special permit, so long as such uses are in harmony with the general purpose and intent of the bylaw or ordinance. If you read the special permits that have been issued to Thayer Nursery, it's always with the idea that the residential character of the neighborhood will be preserved and protected. When I called Anne Marie Fagan to ask why Joe Prondak wasn't enforcing the cease and desist order, she said to me, I don't know how many trucks a nursery needs to operate. It's not about that. And the concern that has been discussed here in the prior hearings about the health of the business, the welfare of the business, et cetera, is not the primary concern. Section 40A of Mass General Law says that the primary concern has to be the residential character of the neighborhood. How many dump trucks preserve the residential character of the Scotts Woods neighborhood? 0. That's my contention. On the bottom of page 16, Judge Sand says, "We now come to the central issue in this case to determine the validity of the landscaping business on Locust. The bylaws do not define the term landscaping business. A landscaping business provides landscaping services such as lawn care and maintenance, grading, sodding, tree work, landscape design, snow removal on other properties, and would also sell plants, loam, mulch, firewood grown on or off the premises. A landscaping business would need to store on its premises the vehicles and equipment needed to perform its services, such as pickup trucks, dump trucks, trailers, snow plowing equipment, as well as materials for its services, including mulch, loam, gravel, and sand. The bylaws, the Milton bylaws, authorize neither as a use as of right nor by special permit. The board, the Zoning Board of Appeals, could never authorize these uses at Thayer Nursery by special permit. And what Judge Sand said was that they would have to have a variance to operate these types of businesses. Number 4, my point number 4 on the bottom of page 17 is the most interesting, I think, because what it talks about is what the Milton bylaws allow in terms of vehicles on a property. And if Joe Prondak doesn't have a copy of this decision, I'd be happy to give him my copy, because Judge Sand says that conditions 3 and 12 of special permit 4 allow Coulter to garage on Locust up to 2 pickup trucks, 5 dump trucks, 6 14-foot trailers, none of which are automobiles, in the district. The garaging or maintaining on any lot of more than 5 vehicles when accessory to a dwelling may be authorized by special permit. So if you have more than 5 vehicles, you have to have a special permit, and it has to be accessory to the dwelling. Not accessory to the business, but accessory to the dwelling. So then he goes on to say, bylaws section 3A7C. Additionally, the garaging or maintaining on any lot of more than 5 vehicles at any time is not an accessory use unless a special permit is granted. Bylaw section 3B1A. The maintaining on any lot of any commercial vehicle is not an accessory use, except that one such commercial vehicle may be maintained, provided that such commercial vehicle is garaged. You can see that there were at least 5 dump trucks, front-end loaders, bobcats, trailers, pickup trucks on the property, and it clearly says here that you can only have one and it must be garaged. The bylaws do not define the term automobile, commercial automobile, or commercial vehicle, but a dictionary definition of an automobile is usually a 4-wheeled automotive vehicle designed for passenger transportation. So what they're saying is, if it's an accessory use to a dwelling, we're talking about passenger vehicles. None of these are passenger vehicles. Josh keeps passenger vehicles. His sister keeps passenger vehicles, but these are in addition to all of these other vehicles. And I know of no special permit that has been issued to allow for more than 5 vehicles. And then, in addition to that, I would contend that the majority of these vehicles are commercial vehicles. The bylaws, to wrap up, the vehicles specified in conditions 3 and 12 would be considered commercial vehicles, and there appears to be neither any previous special permit or variance, nor any provision in the bylaws allowing for their use on Locust as of right or by special permit. At most, it appears that the bylaws would allow 1 commercial vehicle to be garaged on Locust. Clearly, when you look at the situation in John's photos, you can see that there are many, many vehicles, none of which are automobiles. There is no special permit allowing for those to be there, and the bylaws do not permit more than 1 commercial vehicle on a site of less than 5 acres. One last item I'd like to talk about. At the bottom of page 18, it talks about signage, and it says that, that signs are not allowed in a residential area. A permanent sign is not permitted there. And so, to wrap it up, we're just, again, talking about the law. And we're talking about enforcement of the law. And I think in the case of Joe Prondak, perhaps knowledge of the law.
And if I could just add, I think that that was the spirit of this board's decisions in September of 2013 and February of 2014, as well as the judges who have heard this case in various forms since then in Norfolk Superior Court.
One last thing I'd like to say is that I have visited the, Thayer has said that they were looking for other places to keep their vehicles related to the landscaping business. Now, I've already talked about how many vehicles would be permitted on the site, but I did check with the town of Canton and with the town of Stoughton, where they apparently were either leasing land or looking for land, and I have found that none of their vehicles were ever registered in the town of Stoughton nor in the town of Canton. So what does that mean? The law in the Commonwealth says that if you're going to garage a vehicle in a location, it must be registered in that town. None of these vehicles were ever registered in Stoughton or Canton, which leads me to believe that they were never garaged there or stored there. And that's all we have to say.
Okay, thank you. Can I just ask you one question? Have you guys gone back to the Superior Court?
There are so many things going on in Superior Court. I guess I would say yes.
I mean, have you gone back to say to Paul Wilson, these guys are ignoring your order and you want to do something?
No, that's the town of Milton did that, and we went there, and Judge Wilson would not allow us to, I don't know what the term is, but to join in on this. He said we can pursue it on our own. And so what we don't understand is when, I mean, what we see and what we photographed here to us does not look like that anybody is doing what this board ordered them to do and what Judge Wilson ordered them to do, and the town has just been complicit. And that's why we're here. I mean, if you look at Mr. Prondak's letter, I just don't see how he could come to that conclusion, especially since it appears that he hasn't even visited the property since June, was it June 24th that he said in his letter?
Yes.
Yeah, okay.
So you haven't sought your own injunctive relief in the Norfolk Superior Court? It was the town that did it? I'm just curious as to, okay.
Yeah, you'd have to talk to Matt about that.
We're asking you for help. We're asking you to find that the building inspector has not enforced your ruling.
Okay, I understand what you're asking us to do. We obviously don't have the powers that a Superior Court judge has, though. That's the only reason for my question. And we can't hold people in contempt.
No, we understand that.
Okay.
We understand that.
But one of the things that has happened is that Judge Wilson may have signed the order, but Judge Broussard issued the opinion. And Judge Broussard gave the town an injunction. The town has the power to enforce this. The town is not doing that.
Okay, why don't I hear from Mr. Prondak? Or why don't we hear from Mr. Prondak, sorry.
Good evening.
Good evening.
Hi, Joe Prondak, Building Commissioner. Couple of things. So the board issues its initial determination on this came back in September. of 2013. And there have been various appeals as to various aspects of that business that have come in front of this board and gone to court. And at one point, based on complaints from Mr. Johanning and Mr. Rowe, the town, basically myself and Councilor Warren Galvin, went to Norfolk Superior Court and obtained an injunction against the nursery for running the commercial landscape business. We obtained that injunction through the work that we did, the investigation that we did, and the presentation that was made at Norfolk Superior Court, all in the spirit of enforcing the board's order. It is my understanding from the board's order that the Clare Nursery is allowed to run a nursery business. They've been allowed to do that since 1967. There is, in one of those special permits along the way, there is an actual condition that allows for 5 trucks. In the most recent proceedings in front of this board, there was no directive that rescinded that order for 5 trucks, nor was there any clarification or determination from the board as to how many trucks they could have or should have to run a nursery. Sorry. I was at the hearing at Norfolk Superior Court, which resulted in the injunction, and attorneys for the town, attorneys for the Thayer Nursery, and attorney for Mr. Johanning and Mr. Rowe were present. And in the very beginning, Judge Wilson asked each of those attorneys if there was some degree of a farm operation, and would they stipulate to that? And all 3 attorneys at that time said yes. He didn't get into a discussion of exactly what degree of farm operation is allowed there or is permitted under the Dover Amendment, but all 3 parties agreed in front of the judge that that was in fact true. And essentially, after the deliberation and the consideration by the judge, the court did in fact issue an injunction. Sometime after the injunction was issued, we received a number of complaints from Mr. Johanning and Mr. Rowe, and even Ms. Lepore at some points. And I did do investigations. I continue to, in my letter, I spell out some specific times that I was there and some specific inspections that I made, but I am on Hillside Street quite often. And sometimes it's a matter of just driving by because I'm going to another inspection. Sometimes it's because I just want to keep an eye on Thayer Nursery, and it is what I do. What in many of the complaints that we received from Mr. Johanning and Mr. Rowe, the gist of the complaint was, it is a 2-acre nursery. They don't need this equipment. It is not within my power to make that determination. I can't, but being reasonable, I can't imagine. I mean, I see the size of the trees that they nurse on the nursery site. I see that there is no restriction from the nursery delivering trees to a particular site. I can't imagine that you can deliver some of those trees or a large order of trees and shrubs with a small pickup truck. So it takes dump trucks, it takes trailers, it takes bobcats to do that. Without specific conditions from this board relative to those specific items, which appear to be creating the offensive noise, I think really is what a lot of this comes down to, is the noise. I can't make the assumption, and I can't go back to a judge and say, Judge, it's a 2-acre nursery, of course they don't need this equipment. I have to go back to a judge and say, Judge, here is the evidence that this particular truck is operating the landscape business, and it has to be specific in order to win in order to find them in contempt. And essentially, I think that's what Mr. Johanning and Mr. Rowe were looking for the town to do, was to bring this back in front of the judge and get them found in contempt. And I have investigated it, I have continued to investigate it. Some of the specifics of the investigation are in my letter. I am quite convinced that, based on my inspections down first in Stoughton and then in Canton, there were nights that I went down, well, there was one night in particular when I went down there, and as I've said in my letter, there essentially are 2 dump trucks that were regularly parked down in Stoughton. I went there one night, it was about 6 o'clock, maybe between 6 and 7, and there was only one dump truck there. And then as I was driving back north on 138, the second dump truck was heading south on 138 towards that site. I can't imagine at 7 o'clock at night they were going to do a landscape job. They were going to park the truck that was out doing landscaping. So along with that, and I made note of the numbers of the trucks that parked down at that site, and I have seen those trucks throughout town, and I'm sure they do landscaping in other towns as well, but I've seen those trucks throughout town doing landscaping jobs, so I will stop and I will look at the numbers of the trucks and see if those trucks that are doing the landscaping are the same trucks that are parking down at the Stoughton, or the Canton site. And I have not found, in those several sightings that I've had throughout the course of the summer, I have not found the trucks that I've seen routinely parked at the nursery. I have not seen those trucks doing landscaping jobs. I've only seen those trucks doing nursery. So, as my letter states, at this time, we have found that there is no violation and they seem to be in compliance. I'm not saying that Mr. Johanning and Mr. Rowe are wrong. I'm just saying that we have not yet come across the evidence as a town to bring this back to court to find the nursery in contempt. And that's the gist of my position.
Could I ask a question?
Sure.
Mr. Prondak, do you think that Judge Sand's decision relating to the Milton zoning bylaws has anything to do with you?
No.
You are responsible for enforcing the zoning bylaws of the town. Judge Sand says that the zoning bylaws permit only one commercial vehicle on a lot of less than 5 acres.
Judge Sands would have to look at this case in particular, in my opinion, and rule on this case in particular.
He looked at the Coulter case, which is very similar.
Okay, I think, can I ask a question?
Yes.
Joe, when was the last time you went to Canton, and when was the last time you went to Stoughton?
The last time I went to Canton is the last date that's on here.
Okay, that was in July, it's October
Right, but-
15th.
But during the course of the summer, the
Pam Lepori
inspections...
filed
the
complaints, we filed complaints, other neighbors have
Inspections
filed
that I've done over
complaints.
the course of the summer...
And the letter,
Let's not talk over each other,
Sorry.
and,
okay?
all right,
Just finish what you have to say, and then you can
he
respond.
wrote the letter in response to our complaint, saying that he found them in compliance. And he also copied Maggie Oldfield on the letter, telling her that they are in compliance. Did Maggie file a complaint? We filed the complaint. So I'm not sure why Maggie was copied, but she was. And I think since that point in time, then everything has moved from wherever it was. He saw some things in Canton, and he outlined what he saw in the letter. All of that equipment is now as far as I know, all of that equipment is at 270 Hillside Street.
I'd like to hear, I can't speak to the rest of you, I'd like to hear from the Oldfields. I'd like them to take these pictures and tell me their response, tell me what I'm looking at.
Again,
Please.
you want to go through it? I mean, I spoke to him quickly about some of this stuff,
Okay.
but why don't we go through the pictures?
Are you gonna do it instead of them?
I prefer, but if you have questions, then, I mean, you know. Would you prefer, I mean, again, I've went through, but,
Oh, go ahead. If I have questions,
again,
I'll
this
ask.
is part of the mulch.
Sorry, you are?
Excuse me, I'm John Kozlowski. I represent the respondents, the Thayer Nursery.
Go ahead.
And this is, again, the loom, right now, trust me, they're trying to comply with this horse cease and disorder. They've set up another facility in Canton. They have all their landscaping, equipment, everything, the loom, everything, deliveries are being made there. But in connection with the nursery, they also utilize these products, these trucks, these equipment. So what you see here in this picture of this loom, this is a delivery that's utilized in connection with the nursery.
What does that mean exactly?
They, again, they have fields out there, they groom the area.
So this is loom this is
This is what's used.
It's
yeah.
being spread on the nursery
It's being
site.
spread on the nursery. They
And these 3 trucks, let's just take these 3 trucks that I see in the first picture. Are they used exclusively in the nursery operation, and if so, for what?
Well, not, for the most part, well, not for the most part, there's 2 crews with regard to the landscaping. All right, so they use 2 trucks. But if for some reason they need another truck, what they might do is swap out. You know what I mean? So every day you usually have 2 crews of landscapers going out.
And those crews are going out from Canton?
Correct. But at the same time, I don't want to mislead you, if, let's say there's a job that's for landscaping that's a half a day, what they'll do is they'll take those laborers and and basically loan them over to the nursery because, I mean, the nursery constantly has things that need to be done by these laborers. So what they're doing is, although they may have in common laborers, as pointed out by Mr. Prondak, they have bobcats and stuff utilized with regard to the landscaping business at the Canton location. He viewed it. They also have a bobcat in connection with what they utilize at the nursery. Equipment like that, let's say they were getting a big load of trees in, or something like that, and instead of going out and renting a bobcat from a rental agency, they may borrow the bobcat from the landscaping business to utilize in connection with the nursery business. So what's happening here is that they're sharing labor, they may share equipment, but other than that, the 2 portions of the business are separated. They have the landscaping business, which is being out of Canton, and they have the nursery business. So there is some overlap, but the landscaping business is not being run out of the Moulton property. The Oldfields are trying extremely hard to comply with this cease and desist order.
Just to go back to this first, so some of these 3 trucks that I'm looking at here, are some of those
Are those-
trucks,
Are those
The one on the far right is broken down.
Right.
but
Is that a nursery truck?
Yeah, the one with the caution tape on it.
Yeah, all right.
Yellow tape.
so are any of these trucks ever used in connection with
Yeah.
the landscaping business?
Yeah. We rotate the trucks from side to side, based on what the scope of the work is and the needs for the deliveries are.
Can I just point out, there are 5 trucks in the pictures.
Just looking at one,
Okay,
we're talking
sure.
about one picture.
Sure.
All right, take me to a 5-truck picture.
You have to put them together, and you have to use points of reference to figure out which truck is which. You can use the excavator in one picture, you can use the pile of mulch in another picture. If you look at the truck starting on the left, the first picture, and you move your way over, you can count 5 trucks.
Are there 5 trucks on the
We
property?
just stipulate whether there are 5 trucks there or not on this particular time.
I don't want to have to go through these pictures. Are there 5 trucks?
Honest to God.
No,
Okay.
Well, again.
You'll note the date and the time?
no.
Again.
And on that particular day, we were doing a project at the nursery to become compliant with our permit. We were doing a big drainage project at our facility to work towards and what we need to do from a permitting perspective.
At the same time, they're working with the town and they're seeking a special permit. And to comply with the building department, there's certain things that are being requested to be done, that are big projects on the job. Typically, an example of that is typically if you know, the landscapers aren't going out, what they'll do is they'll utilize the work for us to try to comply with the request of the town to come in compliance so they can proceed with trying to get a special permit.
If I'm not wrong, this was a Sunday?
Just to go back to my point, though, some of the trucks that are stored on the site are used in the landscaping operation.
Yes.
No, I'm sorry.
At times, yes. They're not 100%, as we stated, throughout the whole year.
Why is that not a violation of the
No,
the
because
court's
they're not-
order?
Wait, let me, again, because they're not being stored there, all right? They're operating out of the Canton project. They may be on the property at different intervals, depending on what's going on. They're not being stored there, they're not operating out of there, but if there's a big thing, if there's, again, they're digging a trench for drainage purposes as part of the process, that's a big job. They have the whole crew over there trying to do that project. There's other aspects of it. There's,
For instance, we have our composting permit, composting pile down the street. So what we have to do is bring up our compost to backfill the trench or to use in our fields.
Can I just make a point?
If I were to go out to the site right now, how many trucks are there?
at the nursery?
Day and nursery, how many trucks are there?
Two.
2 or 3.
And you need 3 trucks to do the nursery business?
One's broken down.
One's broken.
Okay, but when it's fixed, you're only gonna have 2 there?
That's a landscaping vehicle.
So the landscaping vehicle is the one that's broken down, and the 2 that are there, parked there tonight, are used exclusively for the nursery business?
Yeah, but what
Never,
happened?
never for the, it's a simple question.
No,
Ne-
not at all.
that's
Well, then,
not.
how are they not involved in the landscaping business then? If they're there tonight, parked overnight, how are they not involved in the landscaping business?
I don't think there's a distinction between the nursery going out and renting from U-Haul a truck and bringing it there and using it in the operation of the nursery, than borrowing a truck from the landscaping business to use it in conjunction with the nursery. That is being utilized in conjunction with the nursery business, so it's not a violation of the order. Now, if these trucks are, as I understand it, probably the biggest complaint in this whole thing is the loam, the mulch, the construction debris with regard to the landscaping projects. That's all been moved off-site. Even the loom for the, other contractors come, other builders come, other landscapers come, looking to buy in conjunction with their purchasing of stock from the nursery, loom, mulch. They send them to the Canton property to purchase it, although it may be incidental to the nursery business. They don't want to even go down that road. That's all sent over to the Canton property. However, in conjunction, and here's a,
These are sites from Canton.
this is the Canton property right here. These are the,
It's a bobcat, it's a pile of mulch.
So-
Here's the trucks, green wagon, cement mixer, van.
And some equipment stays on job sites.
Wait, let's just go back to tonight.
no,
Let's take one of the landscaping trucks
Mhm.
that's parked at the Thayer Nursery tonight. So tomorrow morning is a job for that truck to do, a landscaping
no,
job.
no. What happened in that case was the truck broke down, so they took a nursery truck and now they're using a nursery truck in conjunction with the landscaping. So it's more of a sharing of assets as opposed to running the business.
So, okay, this sounds a little bit like a Ponzi game to me, but it's a really simple question. Are any of the landscaping trucks used in the landscaping business parked at their nursery tonight?
No.
Are they ever parked at their nursery overnight?
Yes. If we have,
So, for example, the pictures that we were shown of a truck leaving their nursery, going down the road, arguably with firewood in it, does that happen? That,
Well, again,
if
Okay,
that
so as
happens,
the
if
chief-
that happens, how are you not in contempt of the court's order? And how are you not in
Because-
violation of this board's orders?
but because again, they're not operating again, if one of the trucks in conjunction with the landscaping business goes on the property, that's not a violation of the court order. The landscaping business, like any other landscaping business, like any other builder, any other homeowner, consumer, they can go there and purchase and acquire the products or the trees, incidental things associated with the nursery and take it to a job. Again, and I point out, Josh Oldfield, who runs, again, I haven't spoken to him about that picture of going down the street. He lives on a property adjacent to the nursery. So, again, we don't, it's my understanding that's not firewood in the truck, all right? I mean, it's the middle of the summer, August, September.
So is it, what is it?
It's October 4th. It was October 4th.
Again, I don't know what it is.
All I can say is what we have are receipts from our suppliers saying where our firewood is being delivered, the dates it's being delivered. There's our firewood going to 495 Turnpike Street. Here it is, our invoice, June 16 for loam going to 495 Turnpike Street. July 3rd, loam, 495 Turnpike Street. 8/31, 495 Turnpike Street. 9/15, 495 Turnpike Street. 9/22, 495 Turnpike Street. 6/13, our mulch. Where's it going? 495 Turnpike Street. 7/31, another load of mulch. Where's it going? Canton. 9/1, here's our check for our rent for Turnpike Street. October 1st, there's our rent check for Turnpike Street. 5/15, here's our rent for Stoughton. 4/19, there's our rent for Stoughton.
If I could just ask a question, are any of these vehicles, if the vehicle is garaged in Canton or garaged in Stoughton, is there a requirement in the Commonwealth for it to be registered in that city? Yes, there is. Yes, there is.
Again,
Stay away from
It's a
that.
farm
But that's not
vehicle.
really,
It's
that's
a
not
farm
an issue for
vehicle.
us
Stay away from that, yeah.
to decide. What I want to know is this. This is really an impossible task for us tonight to do this. Because this evidence that's before us is ambiguous at best. But what I want to have a clear answer to this question. For every landscaping job that Thayer Nursery undertakes to perform for anyone, does the truck originate in Canton or Stoughton, come to Thayer Nursery in Milton, pick up the stuff, and leave and go away and do the job?
yes.
No,
Wait, I'm sorry,
no,
what?
it does not. It goes from Canton. Our drivers come up from Rhode Island. They drive straight to Canton. They pick up the truck, they pick up their mulch, they pick up their tools, and they go to the job site. If we then need product on our landscape jobs, then I have a nursery guy deliver some product to the job site. If on occasion, we need a truck, if we have a really big tree and we need a truck and a trailer, then we will have to shift trucks and trailers around to have that come back to the nursery. We have gone through great pains to try and separate it. And this was our issue all of last year. We talked about how challenging it was going to be for Joe Prondak in this town to enforce, because we are so intertwined. We've been intertwined for 50 years. And to all of a sudden expect that we're going to go and not be intertwined, buy new vehicles, buy new equipment, is insane.
Can I point something else out too? If there's another landscaper, if there's another builder out there that wants the same stock, the same thing, they do the same thing to deliver it to them. That's part of the nursery business, whether it's going to the landscaping portion of the job, or if it's going to another project somewhere else that's not, has nothing to do with the nursery, Thayer Nursery landscaping. That's how, in other words, that's the sharing of the assets that they utilize. And if they can do that to deliver it to ABC Landscaping Company, that, again, my reading of the cease and desist order is that they can do it because that's part of their nursery business to the landscaping portion of the business. And again, I think they've gone over with removing any, other than what's actually utilized in connection with their own fields, the loam and the mulch. And when they have people coming in looking to purchase that, because in there, you know, they send them over to the Canton. That's all delivered over there.
Could I show something? Remember, we had a ruling saying that no construction material could be at the nursery. This is Josh Oldfield's house. These are cement blocks. These are pieces of slate. These are piles of stone. This is August the 17th, 2014. Now,
Which was a Sunday.
I understand, I realize that it may be difficult, but these things were strictly prohibited. And it was agreed by the Oldfields that this type of material would not be maintained at the nursery. And I challenge anyone to tell me what these cement blocks have to do with a nursery business. So what I'd like to say is that we have been waiting for a very long time for compliance. The original order was issued in September of 2013, and this is August the 17th of 2014. And so I find that there's absolutely no way you can say that anyone is struggling to comply or that they're in compliance when this construction material existed at the site on August the 17th, 2014.
Probably still there.
If I may add on that one, I have seen that stuff. It was part of what I saw in the inspection, as explained to me by Ms. Oldfield, that it is not there for sale. They're not selling that stuff. They're using it to create the paths and various displays that they use to sell their nursery product. And I mean, I don't see any trucks going out of Thayer Nursery loaded with, trucks or cars, going out of Thayer Nursery loaded with masonry stuff. And you're right, the stuff that was there in August is probably still there today because they're not selling it.
Judge Sands doesn't say that you have to sell it. He says you can't have it.
You can't store it there.
Again, we're not
It's part of the landscaping
We're not
business.
hearing Judge Sands' decision.
I agree, we're not hearing Judge Sands' decision.
I mean, if you look at these two, the first question in my mind is how could these be utilized in a residential property? What they utilize is with regard to the nursery and the displays. I mean, there's no tables, there's no application whatsoever for these things for, I can't imagine, for a residential property.
Okay. Do you guys have any questions?
Maybe you just answered this question, but so the picture with the stone blocks and the dust, this stuff here, is anything in that picture used in the commercial landscaping business?
No. So if you've been up to the nursery, you'll see that we are in the process of digging a drainage trench, and we are in the process of flip-flopping our nursery around. So previously, we have a 65-foot existing buffer between us and their property. Mm-hmm. And previously, we had our mulch piles there, we had our stone piles there, and right now, we are in the process of flip-flopping the two quadrants around. So that quadrant that was closest to their house is now a field. So what we had to do is we had to go in and dig up almost an acre of stone driveway. We dug it up. We then had to stockpile the stone on this quadrant over here.
Yep.
Then we had to bring in compost to fill in that new field, the new grow-out area we just created. And down the street at 217 Hillside Street is where we have our Mass Department of Agricultural Resources composting permit. So then we need to bring our trucks down the street, we load up with the compost, we then bring it back, and we're creating a field.
Okay.
This project has been going on all summer.
Fine, so nothing in there is commercial?
No.
Commercial use. Is that pile of mulch in that picture for commercial use or for residential use? Or excuse me, or use For the nursery business on the site?
It's used on-site. We
Okay.
mulch in our plants. We have 5.3 acres on the original site.
Yep.
We then have 3.68 acres across the street, and so we use it on both
Okay.
areas.
That's what I want to know.
Junior?
How long does it take to use a pile of mulch?
We keep it on site when we get new plant material in. And then, as you know, this summer, August and September, we are in a severe drought, so we are always mulching our plant material in to keep them moist. So we got that pile in, I don't know, maybe July or August, and it's currently gone. So we use it as needed when we bring in our plant material. So it's kind of hard to say.
The thought that I'm having is that maybe too much of it comes in at any one time. Maybe bringing it in as needed would be helpful for the situation and make your neighbors like you better.
We do bring it in as needed.
A little more.
And we were told that we could bring it in for our own properties. There are 4 houses that we own in the neighborhood. And that's why
I understand that, but I can do that too. I could bring in mulch and just leave it there, and it could get smelly, and my neighbors might not like me either. So if I'm going to use it, yeah, I'll bring it in.
Yeah, so,
Well, it
yeah,
is,
yeah.
it is. I'm just suggesting that these are the things that make for nice neighbors. And it's going to be it's going to be very difficult. As you say, there's always a reason for all of these things. It's hard to untwine the two businesses. You know, those things which look very much like something that's not allowed there anymore, you have a reason for that. You have a reason for this, you have a reason for that. At some point, you know, the camel's back is loaded here, so we're trying to take some of these things off.